Okay, let's get started. And once again, welcome. And thanks for joining today's session, How Probate Cash Can Help Your Clients and Your Firm, a webinar brought to you by Probate Cash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. Mark will address questions after the presentation. If your question is case specific and confidential, please indicate that in the chat, and someone will respond separately after the presentation. Our presenter today is a professional with extensive experience in the probate field. Marc Harris is an attorney admitted to the Florida Bar in Southern District of Florida. Marc is also a member of the Florida Bar's Real Property, Probate, and Trust Law section. Marc has been working in the specialty finance industry for over 25 years and involved in purchasing over $100 million worth of assets. Most of his purchases are pursuant to various state laws, require court hearings, many of which Marc has either attended or appeared as counsel. And as the CEO of Probate Cash, Mark is now spearheading a relatively new industry of purchasing interest in actively pending inheritance claims from estates or trusts. And so now, without further ado, let's hear from Mark. Mark, can you start us off with what Probate Cash does?
Yeah, thanks, Molly, and I appreciate everybody being here. I'm seeing folks from all over the country, and it's made up of lawyers, paralegals, and even judges. And something I haven't seen before is actually Firefly's intelligence note takers. So that's new for me. So thank you everyone for joining. I am Marc Harris. I'm the CEO of Probate Cash. I'm also a lawyer, as Molly said. Probate Cash is a company that purchases inheritances. We purchase really portions of inheritances. So when a probate case is opened up and beneficiaries are waiting for their inheritance, usually they're learning even before the probate is opened up that that probate even exists. So you guys on this call all know it exists. But for a lot of people, they're counting on their inheritance immediately, and they go to the bank to look at the bank account. They try to see if they can quickly sell the property. And that's when the banker asks them for their letters testamentary, or the realtor does, and they say, "What is that?" And then they realize that not only is there something called probate, but probate can take a year or more, at least many, many months, and that's if it's not adversarial. So suddenly, instead of getting their money, which they thought they were because that's how the movies portray it, they then are stuck and even need money sometimes to open up the probate case. So that's where probate cash comes in. We provide upfront money in exchange for a purchase of the inheritance. And the inheritance purchase, it's an assignment of a portion of the inheritance, and these are non-recourse. And so we make these advances prior to claims period expiring, prior to it even beginning. And our purchases are subject to those creditor claims and any other kind of challenges that you'll see and other obstacles in the probate courts.
Okay, but now how does an inheritance purchase from Probate Cash work?
Okay, so if somebody's interested in selling a portion of their inheritance, and these are people, as you can imagine, the average customer of ours is somebody who is a beneficiary of an estate where mom and dad maybe bought a house, in the 1980s, where I was a teenager, so that'll age me out quickly. So they bought it in the 80s. Let's say it could be in Atlanta, Georgia, Los Angeles County, wherever. They paid a couple $100,000 for it. In Los Angeles County, that property is worth well over $1 million. In Atlanta, it's probably getting close to that, and other cities. But the families themselves don't have a lot of liquidity. And so these beneficiaries who are counting on the inheritance, probably not any estate planning, may or may not be a will, but there's going to be a probate. And these folks who are counting on the inheritance suddenly are not receiving their inheritance because of probate and need money. They need money to fix up the estate property. They may need money just to live off of. So it's one of those things that nobody likes to really talk about when someone passes away, is the practical aspect of how does this all work? And if you didn't have the benefit of your family having estate planning or a need for real estate planning, or like a lot of families, they don't talk about death. That's a subject that, of course, not a lot of people want to talk about. Here you are now. You have to wait, and it's a very uncertain, scary moment for folks, and they're in need of cash. Usually can't access money through traditional loans, And that is when probate cash comes in. So how does it work? Now that I've rambled on a little bit, it works by us taking a look at the probate case. So we'll talk to the heir or talk to whomever's referred that person to us, sometimes the probate attorney. And when we have underwriters in our company who are very experienced paralegals, basically, they are paralegals, and they're looking at the probate case. And we're just making sure, like you would with any purchase, that number one, the beneficiary who is asking us for money is indeed a beneficiary. So we want to make sure they're an heir. Number two is then the assets of the estate and how are those assets going to flow through the estate? As I mentioned, there's that real property. So is there a mortgage, reverse mortgage a lot of people have taken out? What is the property worth? Is there equity in that property? And then what would the share of the beneficiary's inheritance be? What should they clear? And that takes in that we take into account the condition, of course, of the home. A lot of times, the personal representative of the estate uses our money to fix up the home. A $25,000, $50,000 improvement to a house can be a significant difference in the sale value, a fair market value, compared to selling it to, for instance, a cash buyer, which doesn't really help any of the beneficiaries, but it does often get them the money a little quicker. So that's when we come in. We'll take a look at the estate, and when we decide to do the advance, a couple of things before we'll actually pay the money. Number one, we want to talk to you, the estate attorney, and most of you are with a firm here who represents estates, just to let you know, one, that we've been solicited by somebody to do who needs money, wants money from us in exchange for their inheritance. Number two is we will then file the assignment of the inheritance with the actual probate court. So that'll basically say, John Smith, have assigned $50,000 of my inheritance to probate cash, and it's directing the personal representative to pay probate cash the first $50,000 of that person's inheritance before that person receives any money. Again, all subject to creditor claims, attorney's fees, all the normal folks who would get paid first. We know where we are on the pecking order for the most part in getting repaid. And that's why we purchase portions of inheritance, and we're pretty cautious of how much of an inheritance we'll buy. We always also want to keep our customers' skin in the game as far as them having an interest to see in the outcome of the probate, so they'll be interested in seeing this matter closed up.
Okay, now I know you've mentioned in the past to me that funding these purchases can take only 1 to 2 business days. How can probate cash fund so quickly?
Yeah, so I don't even know if I did mention that, but but we've done this a few
Right.
times. So
As I've in the
yes,
past.
that's correct. We can fund the purchases of these advances sometimes same day, 1 to 2 days. So I've talked about what these purchases are a little bit. Let me quickly explain what they're not. They're not a loan. So these aren't loans. We don't do a credit check. We're not interested in the credit score of our customer. We're not we're not interested in in whether there's collateral because we're not taking any kind of security interest. We are just interested in the inheritance that they're going to receive, subject to the creditor claims and the other issues that may jump out. So there's no, as far as repayment, we know that we're waiting to get repaid when the probate case closes. Usually that's the case. People can repay us anytime they want, but we know that it's going to probably come out of the assets of the estate. And that's where we wait. So there's no interest rate associated with this because it's not a loan. And there's no like monthly payments that are due or anything like that would cause a default like a traditional loan would.
Okay, now what are some of the pros and cons of an inheritance purchase?
Sure. So if I'm an attorney and a beneficiary is contacting me, which I'm sure the beneficiaries are contacting you saying, when am I going to get my inheritance? And first of all, they're probably not even your client. You're representing the personal representative of the estate. You're representing the estate. But that doesn't stop the beneficiaries from calling you and seeing what's going on. They're frustrated. You're getting the calls. So one is it takes pressure off of the personal representative and the law firm is to at least know that there is an option for these folks to obtain some money up front to sell a portion of their inheritance. And that's just a lot of it is just knowing, right? Just the folks on this call, your paralegals, your counselors, you're supposed to counsel. You should at least know when somebody needs money that there are options available for them, even if they can't qualify for a loan. And then, it's something for them to explore with you to explore whether an advance works for them. Second, as I mentioned before, the properties, which is sometimes the sole asset, but certainly the major asset of the estate, a lot of times those properties need repairs to be sold. Sometimes those properties have taxes that are due. Our advances are in purchasing the inheritance or even getting money to the estate can be used for the purpose of renovating the home for fair market value. That also is important to number one, of course, it's going to benefit all the beneficiaries. Number two, though, being able to get money over to beneficiaries of the estate, the money buys them time, and so it allows for the house to be renovated, allows for enough time to go by so everybody is getting fair market value and takes some of the pressure off. Those are two pros that jump out at me. A negative is that, as you're probably wondering, what are our costs? So we do charge fees, and the fees are expensive. This is not inexpensive money for beneficiaries selling their inheritance. Our fees start at around 25% of the amount of money that we're purchasing. So if we're giving somebody $50,000, let's use an easy example, $10,000, and we'll do it as low as $5,000. But we're providing somebody with $10,000. The least amount of money it usually costs is $2,500. So they have to pay us back $12,500, and it goes up from there depending upon when we're actually repaid. So therefore, if you're using the money to fix up a house and $25,000 of repairs can make the house resell for $75,000 to $100,000 more, which is very often the case compared to what a cash buyer would pay. It's absolutely, most likely, a very good idea to discuss with your advisors. If you're using the money to take the kids to Disney World, buy a fancy car, use it for more luxury items, things that aren't as big of a necessity item, I'd probably put the brakes on that. I would say, we will buy your inheritance, but that may not be the best use of your funds. This is you should do what you want to do after talking about it with your folks, but that's an expensive way to go to Disney World. So I would caution folks that if you can find other ways to raise money, if you have the time and ability to qualify for a traditional loan, or you have friends, that may be the way to raise funds as opposed to selling your inheritance. But if you don't like loans, you don't like the repayments, you don't have collateral, you don't have a good credit score, and you need money immediately, we're the folks to see. Probate Cash can usually get that done, and we do it with the visibility and usually assistance, or at least some informal assistance of the estate attorney.
Okay, now I think you've touched on this already a bit, but just circling back to the title of this webinar, how can Probate Cash really help clients and law firms?
Sure. So, you're right. I did touch a lot about that, how it can help your clients and things that you guys should discuss with your clients, and know that we're an option, that Probate Cash is somebody that can give folks who need the money. Um,
Mhm.
we also have seen law firms who, if you're in a law firm that's spending a lot of money marketing to new clients, and you're getting a decent flow of new probates, but those people don't have money to pay the cost to open up the probate. Now, it depends on what state you live in. In some states, you're getting paid as an attorney, kind of like us, out of the inheritance, when the probate closes. But other states, you get paid a retainer, like other traditional practices of law, and their cost involved. And it's got to hurt to turn away potential clients who have property, who are going to have assets at the end of the day, but you can't afford to really represent them because of the upfront cost of carrying your office and carrying the cost of filing fees and your time. We can provide advances to the beneficiary, usually the beneficiary who's proposing to be the administrator. for the purpose of opening up the probate. And in those situations, that'll make sense for law firms. You don't have to tell people no, or otherwise you would have represented them and send them down the street to folks um, who can afford to carry the cost of the probate.
Okay, perfect. Now, talking about beneficiaries a bit, how does an inheritance purchase to one beneficiary affect the other beneficiaries who are not assigning portions of their inheritance? And how does that purchase affect the probate case?
So yeah, for lawyers, that's really important to know what am I getting into as an attorney if a beneficiary is taking money from probate cash. Uh, so when we're talking, first off, we are in contract privity only with the beneficiary who is receiving money from us, who's selling us a portion of their inheritance. We're not in contract privity with anybody else. So it is up to that heir to repay us. And usually, again, we're filing the assignment in the probate court. But these are non-recourse. If there's a shortfall or our customer doesn't have enough money to pay or not getting any money, we cannot look to any of the other beneficiaries for repayment. So if there's a shortfall there, if there's three beneficiaries each getting $50,000 each, and one of the beneficiaries owes us $75,000, we do not come look for the shortfall to the other beneficiaries. Number two, we're not a creditor of the estate. This is not something that we're going to see as a creditor claim where we say, hey, we get paid now because we made an advance to John Smith. That's not how it works. Again, we're only in contract privity with them. So the third is it should not prolong the probate process either. This shouldn't take any real material work, additional work for the attorney because of the sale and purchase of a portion of an inheritance.
And can multiple beneficiaries get an inheritance purchase from probate cash?
Yes, in fact, of course, as you could imagine, that is a common thing that occurs. Somebody takes sells a portion of their inheritance. They get paid from us in a day or two. They're very excited that it worked out. They realize it's real, that we actually do pay real U.S. dollars, and they then, of course, tell their other beneficiaries, and so suddenly they're more beneficiaries. And then also with that, people come back to us for additional sales. Because as I said, if we're going to buy a portion of the inheritance, we're going to buy a very small portion if the probate case is just beginning, like especially if it hasn't even been filed yet. Now, to
Mhm.
be clear, there's always a decedent, so that's we're not anticipating somebody passing away, but there's always a decedent, and if it's at the beginning, we don't know what's coming down the line, and neither do y'all as attorneys usually. So we're being very conservative because we know there could be a challenge. We know that there could be some creditor claims. There's in some states you could have Medicare that comes in even after the claims period expires. So we will be more not aggressive, but less conservative as the each stage of the probate goes. So when the claims period expires, then we'll say, okay, we think that our beneficiary is now going to receive more money. It's getting a more clear picture. If we're petitioned for final distribution, then we kind of have a better picture of what's going to be received and we can give more money. So we can give multiple advances and also to the personal representative. We can make an advance to the personal representative who's either an heir or not an heir, but has the power to take money for purposes and consistent with their fiduciary duties. And that
Okay,
would
now
be like buying, fixing up the house and things like that, the estate property.
that makes sense. Are there any laws that govern inheritance purchases?
There are, but they're not a lot. So the oldest law that governs these inheritance purchases is in California. And that's if you're taking notes, which I know the Firefly's AI note taker Alex is taking notes. So the California probate code is 11604.5, 11604.5, and that's the California code. As you can imagine, it's California. It's very consumer protection oriented. This probate code there gives a roadmap or what's required to be in our contract. It's not a very legalese contract, pretty easy to understand. We then file the assignment of the inheritance into the probate court. And California is really good because it also then requires the probate cash to be in the order for final distribution. So it's a very clear, transparent way that makes it easy because of the law in California. A lot of attorneys in California are familiar with this business compared to if there is no law in your state. If you're in Georgia, you're in South Carolina, you're in Texas, and most of the other states, there is no law, and it's kind of like, what is it that you guys do again? And that's really the message of this webinar is to also, not just show that how it works, but that it's real, that it is an option. It's a very important and often necessary option for beneficiaries of estates to know that we're here and we can provide this money during the time of probate and fill that need where that they would otherwise not be able to receive money during the probate process. So the another state that has it is Utah. It's a rather new statute. It's on the California model. Utah 75-3-918, 75-3918. So that's a Utah a probate code. And it's a very similar to California, absent a couple of other differences. So they're minor differences. In the other states, however, we basically use the framework of the California and Utah statute. So if we are in Georgia, we are in Texas, we our company has the same template contract. We make the same disclosures. We are very careful that our customer understands what they're receiving from us and what they're selling to us of the inheritance. And not only that, but maybe it's the attorney and me. I actually require our customers to participate in a recorded closing call before I'll send the money. So we can go over everything again, the material terms that are in our contracts, just go over it on a recorded call so they really do understand. I want to make sure there wasn't any kind of misunderstanding in their conversations with any representatives of our company. And after we've completed that recorded call, we've usually talked to the attorney for the estate. We've recorded the assignment in the probate court. And then at that time, we fund the purchase price to the beneficiary.
Okay, great. We've already gone past our 15-minute mark, but as I promised, Mark, I want you to be able to answer a few extra questions. But if you need to leave now, we'll send everyone a link to this recording of the presentation and these questions and answers. Also, if you have a question that you think of later, you can always call Mark at 561-476-0018 or email him at marc, and that's MARC, at probatecash.com. So let's get to the questions. Okay, the first one is, I represent a plaintiff who's challenging the heirship. Do you make purchases in adverse cases?
Yes, you know what, and I should have probably discussed that. So that is a good question. We do. That those can be more tricky because oftentimes we're purchasing an inheritance that doesn't yet exist. Someone's been written out of the will, or they're somehow not being taken care of in an intestate situation, so where they should be. So in this, if you are representing a plaintiff in a case and they're challenging that they are a beneficiary, then that is something that we can help make purchases of their hopeful and future inheritance, and get the money to help them during the litigation process. Now, hopefully, you as an attorney, I'm hoping that you're doing this on a contingency fee and believe in the case as much as your client believes in that case. I don't like to get into a situation where I'm just funding lawyers in an adversarial case where I'm getting stuck into a case that I can't get out of because I'm that far deep. But we do participate in these cases where we'll provide money to plaintiffs of cases in adversarial situations.
Okay, we have time for another question. How do I help my client qualify for a purchase?
Sure. So call us, call us. If you don't, you just want to refer your client to us, or oftentimes it's going to be a beneficiary of your client. I know how these work. It's going to be you're always in conversation with the personal representative. Personal representative may say, "Hey, my siblings keep calling me. They're driving me crazy. They need money." Eventually, those people are going to be calling you. You can direct them to us. And our office will eventually be calling you before we'll make an advance. We believe in no surprises. We want to make sure that the estate attorney is going to know that the transaction is going to come down the line. But we're going to ask you questions about whether whether you anticipate any creditor claims, whether you know or believe. We know you don't know, and lawyers aren't on the hook for any of this, or it would never work for us.
Mhm.
So we just like your best guesses. We want to make sure that the house is going to be sold, or whether somebody's living in the estate property. Are they moving out? Those are often, when there are problems, those are the problems we see, is that the beneficiaries want to sell the home, but one person's living in that home and they're not moving out, and that's going to cause a potential eviction. Or the personal representative, maybe your client, is just not acting in a manner consistent with the fiduciary duties, and that can be a problem as we try to sort through that.
Okay, we're almost out of time. So again, I want to make sure, if anybody has any other questions, please feel free to contact us offline. We'll be sending a follow-up email with a link to this webinar. And like I said, if you have any other questions, you can always call Mark at 561-476-0018. Or you can email him at Mark, and that's MARC at probatecash.com. Thank you everybody for joining us today, and have a great day.
Thanks, guys.